Right. So I feel like when all of us are introduced to our constitution, one thing we learn in the beginning is that it is very much borrowed. And I believe they call it the bag of borrowings. And I do see that a lot of that, especially when I first got acquainted with what other countries are doing with their constitutions and their founding histories. The one thing I do see a lot of is that I think our Constituent Assembly, not sure how well, but they did attempt to try to inculcate it into the Indian scenario and how I believe the Indian culture and our society played a huge part into how they were planning to inculcate it into our country. And I think what I see the most in our constitution is while they were borrowing all of the aspects from different constitutions, whether it's fundamental rights, I think most importantly, fundamental rights, I think I saw a lot of colonial trauma, which they were trying to use to, I believe, give a lot of power to the state in a way to make sure that that does not happen to us again. And I think that is what I see when I see our constitution, that it is borrowed, yet transformed, transformed into our scenario, right?
Thank you, Kashish. Sarthak?
Yeah, sure. First of all, hello everyone, and thank you, Sanchit, for calling me to this platform. It's always fun to be with Citizens Awakening. Yeah, my thoughts primarily do center around what Kashish has said. So when you send this topic over to me and it read, is the Constitution un-Indian? It got me thinking, what does it mean exactly to say that it is un-Indian? And instinctively, two thoughts came to my mind. The first one is a very familiar argument that most cardinal principles of our constitution are borrowed from founding documents from other parts of the world. But that's a point that I don't want to impress upon right now, for a lot has been written and said on it substantially. There is, I believe, a second argument which says that our constitution is borrowed, which I don't agree with, but I will try to address it first, and then as briefly as I can try to present a counter argument to it. And this is the conception of a conservative argument, as opposed to what Gautam Bhatia might call, and what Kashish also addressed, as a transformative constitution. The conservative constitution has a couple of central ideas revolving around it. The first one is that the Constituent Assembly by itself was not a revolutionary body, and that its authority was derived primarily from the Cabinet Mission Plan of 1946. And then the second argument which substantiates a conservative document is that this borrowed heavily from the Government of India Act of 1935. And this is evinced from the provisions that it has replicated. Most importantly, the preventive detention, then the ordinance making power, which essentially overrides the legislative checks that are there, and also the emergency provisions. Now, to very quickly to address these concerns and argue that the Constitution is in itself an original document, despite all these borrowings and colonial antecedents, is that despite the Constituent Assembly obtaining its legal existence from a colonial act, the first act that the Constituent Assembly did was to declare itself sovereign and announce that it will draft the constitution on its own preconditions. And then another point is there, the principles that were adopted in the constitution, despite as I said earlier, despite colonial antecedents, were very new to India. For instance, the act of providing universal adult franchise to everyone, including democratic politics in a country where no such thing had existed and for centuries we had been subjugated under a colonial rule, all prove that the Constituent Assembly did try to transform the constitution into an Indian one, and by that means also transform the society. And I know I'm going a little above my time limit, but just to very quickly address the familiar argument that we've also heard repeatedly, that the Constitution is a borrowed document and it's a cut and paste document. I think the best counter to that is Dr. Ambedkar's speech in the Constituent Assembly, where he said, "I make no apologies for that," as simple as that. And the Constituent Assembly heard, and there was a lot of cheering for that. And the argument Ambedkar made was that nobody can claim a patent right over the fundamental principles of constitution making. So just because a different country has finalized a provision and it has mastered it, and we've seen that it applies and works well, that is no reason to not include it in our constitution. I have a lot more to say, but of course that we'll surely cover in the upcoming sections. Thank you so much, and I'm sorry for taking such a long.
Thank you so much, Sarthak. Ishan?
Hi everyone, it's quite the honor to be here with such learned colleagues. So a lot of very good points have already been raised about the transformative ideal of the constitution, juxtapose it with its colonial continuity, its colonial legacy, and how that has played out in the story of the Indian state so far. And I'm sure we'll explore that further. I just break this topic down a little bit. Is it un-Indian? Is it borrowed? And is it copied? So there are three different questions. Borrowed and copied speak to whether these provisions have existed somewhere else at a certain point of time. But I want to draw this distinction between a constitution being borrowed versus a constitution being un-Indian, because a constitution could very well be Indian even if it's borrowed, given that the makers of the constitution felt that it was very well, it brought forth the needs and hopes of the makers while they made it. More than that, I also want to, right at the outset, stress on the kind of results that we get depending on the outcomes that we derive from a discussion or debate such as this. Because it's often said that and it's often and you see it very often being mentioned, that there are very systematic deviations that you find from constitutional cultures across the world in recent times. And when we begin to assert, or when we begin to challenge our constitution, the question is what might have been the constitution like, what the constitution might have been like, and the kind of repercussions you might have when you begin to reconceptualize a constitution. So there are very serious questions that emerge out of this debate that I'd be happy to see more discussion on through the course of the session. Thank you.
Thank you so much. Shweta?
Yeah, so since first of all, I'm extremely thankful for being called on to this panel for discussion. And secondly, I'm very excited about the same topic as well. Already many good points have been raised, but going on my particular opinion, I'll say would be that even the word borrowed does not sit right with me when we talk about the Indian constitution, although I do agree that we have picked certain provisions regarding many things from other constitutions. But it's to be noted that we were a constitution that came in that was drafted way after the other countries, because we got independence way later. And that makes sense that already other countries who had drafted a particular constitution which suited their agendas, we picked what we thought was the best practice around the world in that regard, and we amalgamated it in a particular single document. Now we have people like Mark Weber calling it a cut paste constitution, wherein the reality differs from the constitution. But I won't agree with that. Instead, I'd like to agree with you know people like Granville Austin, who call it a social document, because despite picking provisions from other constitutions, we've always the practice that I've seen from reading the Constitutional Assembly debates and such things has been that they've been deliberated upon, each phrase and everything. And it has been something which we have applied to the Indian scenario very well. It's a social document which is set for the Indian scenario. You won't find something like untouchability in other constitutions, because that's not a social issue that most countries have faced. And therefore, I particularly agree with one point Sarthak said, that fundamental principles of equity and equality cannot be patented by any other country or any other institution, saying that since we have provisions on equality and we have provisions giving sovereignty, that is not something you can copy because then there won't be any point to it. And then with that, I'd like to just conclude, and then let's start with the discussion, I believe. Yeah.
Thank you so much, Shweta. Um, Before we begin with the discussion, I'll lay foundation for a couple of things. So as Shweta talked about Granville Austin, um, in Bipin Chandra's India Since Independence, he talks about how Indian the Indian Constitution is by elaborating on how the various the Indian Council Acts and the various Government of India Acts were should be seen as a compromise between um, the leaders who fought for independence and the British establishment. So he says the reason why there were changes and amendments made when it came to representation in elections, or um, when it came to the rights of and recognitions of various groups and sections in society under British Raj, as they call it. The changes were as a result of a compromise, and that's how it should be seen. So it is Indian in that sense. However, Granville Austin, even though Bipin Chandra extends the discussion what Granville Austin lays down, Granville Austin himself in the chap in what in he has an entire separate chapter that talks about India's original contribution to the Indian Constitution, which speaks a lot in itself. That Granville Austin, despite agreeing with the fact that there were a lot of borrowed elements. Borrowed elements is what he emphasizes on more. But then at the same time, when he has a separate chapter that's titled India's Original Contributions, it does hint that he believes that there's a lot of borrowing to it. B.N. Rao was made responsible for traveling the world to take influence from different constitutions. So, I mean, there's very different perspectives to this discussion. It is borrowed in one sense by one person, and it is borrowed in one sense by the other. So, with that, Kashish, you talked about how the Indian Constitution was borrowed. Would you like to elaborate more?
Right. So when I use the word borrowed, I believe, as we have discussed, like all of us are hearing all of your points, borrowed in the also the sense of what Glanville Austin talks about in the cornerstone of a nation, the Indian Constitution. I believe it's inspired, not plagiarized. That's how I see the Constitution. And right. So I believe borrowed to be inculcated in a way that suits us. That's how I see it. But I feel like a lot of major principles of constitutionalism, for example, rule of law, when I compare it with the American Constitution, that I do see that the state in India is put on a different pedestal than it is in America, or it is in a lot of different countries. I think the one thing I gravitate towards most is the due process clause and its history, and the way it has come to be now versus the way it was seen, the way it was not put, in fact, by the Constituent Assembly themselves and the discussions they had around it. So I feel like when you particularly navigate the founding history of the due process clause, we see how it is inspired by other constitutions, but the Constituent Assembly did focus upon what it means to be an Indian, and what Indian nationalism is, and how Indian nationalism is different to, for example, American nationalism or German nationalism. And I think that again ties down to our history. For example, with Germany, they wish to, I believe, create a distinction between patriotism and nationalism after the Holocaust and after World War II. With us, I believe we were trying to tie down to our nationalism and patriotism when the Constitution was being created. And I think reading about the due process clause really gives us an insight into how the Constituent Assembly was getting inspired, and how B.N. Rao talking to us, I think Shweta was pointing it out, and how I think even Abhinav Sekhri has talked about how his discussions with Justice Frankfurt really influenced how the due process clause was removed from our constitution. And now that the judiciary has read the due process clause into our constitution, I think it was during Maneka Gandhi. After that, now that we go back and see Dr. Ambedkar talking about how it is a victory to not add due process in the Constitution. That's what he called it in his final speech. And he called it a victory for personal liberty and as well as national security. Because at that point, in the scenario that we were facing, for them, giving that liberty to the legislature and maybe that importance to the state was very important for them. And I think that is how I see that they have inspired themselves and then attempted to transform the elements.
I think you raise a very important point there. When you elaborate on the borrowed part, you initially you said it in a very strong way. Now, lately, I mean, across social media, especially considering today's Constitution Day, their Facebook posts and Instagram posts that talk about how our Indian Constitution is borrowed in a negative connotation, um, which so to the normal Indian citizen who hasn't picked up and read the Indian Constitution, they talk about how un-Indian it is and how it being borrowed is a negative thing without understanding the entire process that took place. So, Ishan, would you like to extend to that?
Yeah. So, couple of things. One thing is that while the Constituent Assembly was drafting the Constitution, that was also the first legislator to the country, right? So, and what that does, and this is again Granville Austin's argument, that what that did was that it gave the drafters of the Constitution a lot of insight into how systems were actually run in India, and the kind of problems that they were facing. So when people, and I think the kind of arguments that you get for why the constitution is un-Indian or that it's borrowed are typically, as Sarthak mentioned, very conservative arguments. So in fact, I think because it's a very centrist constitution, I think at one point of time, Ambedkar, is it, I think it is while defending the constitution or it's while defending the Hindu code bill, somewhere he says that both nobody at the left or the right is happy with us because of the path that we've chosen to take for ourselves and for India. And I think so that is the kind of critique that we see here, because there were very obvious constitutional compromises that were made. And Kashish mentioned the due process clause, and that's a very complex and interesting history by itself, because you see Ambedkar supporting the due process clause during the drafting committee meetings, and then somebody there switches sides, and then Ambedkar, being the chairman of the drafting committee, has to defend a clause that he doesn't really believe in. And so I think there are very legitimate doubts about the democratic legitimacy of the constitution. It was enacted, it was ultimately the Constituent Assembly was elected by a very restricted franchise, and there was heavy presence of one party, and then there was the oligarchy, and the Muslim League pulls out, and all of that happens. And then you've got people that are not elected, basically, from princely states coming in. Those are the representatives. So there are very valid questions about the democratic legitimacy of the constitution, but to say that the constitution did not pay heed to the ethos in which it was sought to be enacted is thoroughly misguided. Because if any perusal of any article to the draft constitution and later on, you see a lot of engagement with the kind of social situation that the constitution was meant to remedy. So yeah.
Yes, Sarthak. Unmute yourself, please.
Yeah, am I audible now? Yeah, thanks. So Sanchit, before we move on to the, next set of your questioning, I'd just like to build upon what Ishan has said, because I think he's raised some very interesting points. I think there's a very strong need to reimagine the way we conceptualize the concept of borrowing. And I suggest that let us look at the borrowed provisions from the prism of what they sought to achieve eventually in the Constitution. And there were at least two clear legacies of injustices that the Constitution essentially sought to repudiate. And this is again an argument that has been made brilliantly by Gautam Bhatia in his book Transformative Constitution. The first way in which the Constitution sought to change the society was firstly the alteration of erstwhile subjects of a colonial regime into citizens, into democratic citizens. And then, secondly, to end hierarchies. The Constitution very well accepted that the state had not been the sole center of power historically in India. Agencies and structures like caste and gender have also been sources of oppression, which the Constitution sought to fundamentally repudiate. So, my argument is even if most of the central articles of the Constitution are borrowed, the purpose which they sought to achieve was wholly Indian, and there can be no doubt about that. So, in that sense, the Constitution is fundamentally Indian. That's what I feel. Thanks.
Yeah. Shweta, what's your view on the borrowedness and the un-Indianness of the Indian Constitution?
Right. So first of all, I mean, all the major points have been put in beautifully by all these people, and I do agree. Like the phrasing that Kashish used, saying that it's inspired but not plagiarized. Absolutely on point. And as for why I think people, in my opinion, believe that it's un-Indian, might be due to the shifting, or maybe not even shifting, but a certain sect of people believing that I don't know. I just read that this year itself, back in April or something, a politician of our very own country put in that Manusmriti, and no, obviously no offense to any religious text, but Manusmriti is the supreme, supreme code of rules that has to be followed. And because the constitution does not abide by Manusmriti, so therefore, since Manusmriti is Indian, therefore constitution is not Indian, was the argument that he made. Now I do not agree, and I believe no one will, at least in this panel, with that particular argument, because it's right that the scenario in which the constitution was made, it was with a backdrop of us walking out of being colonized. There were riots going on throughout the country, and the constitution makers had a burden to put in a document wherein no further segregation happened in the country, and they were able to pull in the country, and at the same time get rid of some social evils that were obviously prevailing at that point. Discrimination on the basis of caste, sex, a myriad of things that they had to kind of rectify by putting in a code which dealt with this and obviously all the further issues that were going to come. And therefore, again and again, the process of due clause has been talked of. And when B.N. Rao went and met Justice Frankfurter, at that point in USA, the clause of due process of law was something that Justice Frankfurter didn't believe must be enforced stringently, and he was already facing qualms with that in his own judiciary. And at that point in USA, there had been a case, at least not that point, but in the past of USA, the due process clause, by being stringently interpreted, in the case of, I believe, it's Queen versus Dudley Scott, I'm not sure. But in that, basically, the question was that the slavery had been abolished, and that had been questioned in the court of law. And people, the argument raised was that it violated the slave owner's right to property, and therefore such a thing cannot be done. And because due process of law was basically interpreted very stringently, that was upheld, that argument was upheld, and therefore we believe that no, we should put in procedure established by law. But then again, the way constitution has developed with Menaka Gandhi and everything, we know for a fact that at the moment due process of law is our basic structure, right? We count it as that. And therefore, I think that even if people believe that at the starting, by borrowing it from foreign constitutions, it was something that was not Indian, it has, by the very interpretation by judiciary, evolved into something that applies in essence for the welfare of Indians. So it cannot be un-Indian if it is going to achieve that particular goal. Yeah. Thank you.
All right. Thank you, Shweta. So, Sarthak, you talked about the ends the the framers of the Indian Constitution wanted to achieve. So we're going to discuss and touch upon that. Of course, we won't be able to discuss extensively, but have we been able to achieve those ends that we've sought to? I'll lay a bit of foundation. So this is in light of what former Chief Justice of the Delhi High Court said, um, Justice A.P. Shah. He talks about in the past 10 years, on one hand, we've had, um, you know, decriminalizing Section 377, striking down Section 66A, um, and transgender rights, and you know all of these major landmark judgments that we celebrate today. But then at the same time, in the past 3 to 4 years, we've had what he terms as the abdication of duty to defend fundamental rights. When he talks about the Supreme Court, Sarthak, we've talked about the situation in Jammu and Kashmir briefly. So essentially, what Justice Shah says is that there's been outsourcing of the Supreme Court's responsibilities. So of course, there's a lot that we can discuss on this. So since the Supreme Court is the apex court and it is the ultimate defender of our fundamental rights, how far have we been able to achieve the ends we were meant to? Um, they there've been a lot of scholars who back then, during the time of independence, they've talked about how the Indian Constitution would fail. There are people in America who were extremely certain that the Indian constitutional system was too developed for a country like ours that was so underdeveloped. However, we've proven them wrong, and rightly so. And we have those similar arguments that have been made for Pakistan as well. But Pakistan has also evolved over the decades to prove them wrong as well. So, with that, have we been able to achieve the ends that our founding fathers wanted us to achieve? We'll begin with Sarthak.
All right. Well, Sanchit, first of all, there's so much to unpack from what you've just said. At the outset, I should mention that I don't think I have either the specific tools or the prerequisite knowledge to comment on it in a manner that will be of much value. But from my limited understanding, so you've raised, I think, three certain questions. That is, have we been able to achieve the ends we were meant to by our framers? Secondly, has the Constitution failed? And then the Supreme Court's abdication of duty. So I'll try to answer them as best as I can. Achieve the ends you were meant to. First of all, I think the only end that I really feel that has been the subject of debate recently is something that Madhav Khosla has written about in his book, India's Founding Moment. So one of the arguments made by Madhav Khosla was that the Constitution is not merely a tool for governance, but is also a vehicle to usher in a new era of inclusive democratic politics. So if I establish this as one of the ends of the Constitution and try to argue whether this has been achieved or not, I would say it has, primarily because the constitutional transformation of a citizen into democratic citizens of a republic who have been exercising universal adult franchisee. We have seen a rise in litigation, especially public interest litigation, which, well, in today's time has been in the books for all the wrong reasons. But yes, I mean, with the contempt petitions being spiraled here and there. But yes, in that sense, in the terms of the citizens exercising their fundamental rights, I have seen a success, a constitutional success, at least I would call it that. Secondly, the Constitution did not fail us. Now, it did not fail us because of the way the framers drafted the Constitution. For instance, one of the core arguments that was made in the Constituent Assembly was that why are you including so many administrative details in the Constitution? No other constitution all over the world has these banal details of administration of a country. And to this, Ambedkar had responded by saying that in India, democracy is only, I think his exact words were, democracy is a top dressing on on the Indian soil, which is essentially undemocratic. And this is what he meant, by it, that we should all develop a sense of constitutional morality and a strict reverence to the norms of the Constitution. Because had the details of administration been left out of the Constitution, essentially the parliament would have to work them out. And that could have led to a complete alteration of the Constitution. So because the framers concretely laid down the spirit of constitutionalism and a reverence to the Constitution, how to achieve that in the Constitution itself, did the Constitution succeed despite several setbacks, as Shweta called, it has popularly been called the Indian problem in this book called Constituent Assembly, the Springboard of Revolution, which was, of course, a country plagued by a communal partition, almost a very dismal economy, stratified society, and so on. And then your third point, Supreme Court's abdication of duty. Well, there's a brilliant blog that Gautam Bhatia runs, Indian Constitutional Law and Philosophy. He has done a review, a 2019 review of it. I think you read that and that will answer your question. I am in no position to answer whether Supreme Court has abdicated its duty or not, but be sure to read that piece. And Abhinav Sekhri's blog is the proof of guilt. Yeah, those are my answers. Thanks.
Thank you, Sarthak. Kashish?
Right. So I think again, not at all qualified to comment. Also because it's subjective, and also because I am not learned enough, or I don't know who will be, to comment upon whether the Supreme Court is doing justice to the Constitution. But I feel like on the topic of whether the Constitution has failed us, by the virtue of it being fluid, dynamic, and evolving, I don't believe the Constitution can fail us. And I think the fact that the Constituent Assembly focused upon the fact that it is a living document, it will always mold to what the Indian society needs it to be. And by the virtue of it being that, it does do a lot of justice to Indian citizenry. And yeah, but right. And I think there are, some things that, of course, the Constituent Assembly could not foresee at that point. For example, Article 12, if we look at Article 12 and how it has changed now. And I think at that point, the Constituent Assembly could not foresee that any non-state agent would have enough influence or power over the citizenry for it to actually infringe upon the fundamental rights in a meaningful manner. And how now the Supreme Court had to take upon the duty of describing what a public function is, or what public influence is, and how private entities shall be covered under Article 12. But again, making distinctions between the High Court and the Supreme Court, and how the High Court can take in private entities when they violate fundamental rights of citizenry, when the Supreme Court cannot. Though, and I feel like when Sarthak talked about Gautam Bhatia's blog, and how he has also touched upon the fact that there is a golden era of the Supreme Court, in the way that the Supreme Court has not only interpreted the Constitution, but also focused on constitutionalism. And in my opinion, constitutional morality and constitutionalism is what these two concepts are, what have been taking the hit, whether it's from the Supreme Court or whether it's from the state. I believe the Constitution on its own, it's just words, but we make it make sense when we put it to the move, when we interpret it with the people involved, because the law of the land is only as strong as the people involved and the rights of the people involved. And right, so I feel like the abdication of the duty, I believe the one point where I saw it coming into being was the electoral bonds case. I'm sure all of you are familiar with it. And the PIL was filed 2 years ago, but the judgment, the Supreme Court only put a stay on electoral bonds. I think it was 2 months before the general elections, which was again, I believe, a loss on the part of the citizenry and their right to participate in a free and fair democracy. And after that, I believe it's again a lot of subjective matters, whether it's Ayodhya or whether it's the Citizenship Amendment Act, and it's the Supreme Court's response to it. And right, and but my point being that I do not believe the Constitution can fail us as long as we keep evolving it, and as long as we keep our roots grounded in constitutionalism and not the Constitution itself, and how constitutional principles and constitutional morality will reign supreme even over the Constitution, because the Constitution is led by constitutionalism, and the words that are in the Constitution are led by constitutionalism as well. That's all.
Thanks, Kashish. Ishan, on that point, now considering the circumstances, there are people who claim within the legal fraternity that we are in an undeclared emergency. And the reason why the Supreme Court is functioning the way it is because of the state's influence. So, what do you think about it?
Yeah, very tricky question to answer. Uh, uh, so, yeah, so I think first things first, I think whenever, and if you like, I haven't read all of Baba Sahib Ambedkar's writings on this, but the Supreme Court was never conceptualized as the one institution that we would then, everybody would put their hopes on, that this is the one institution that's meant to safeguard constitutional rights and constitutional freedoms. It wasn't seen as being the original intent or the original imagination was all three organs of the state working together to further constitutional goals and constitutional ideals. And the fact that it has all come to the Supreme Court, and the question of whether other branches of the government, nobody even asks the question, oh, are they upholding the Constitution? Or nobody has those expectations, right? So that does worry me a little bit. And to the extent of judicial deference, I'll try and be very safe here and only say that there are limits to what courts can do. Because courts are ultimately run by judges that are not democratically elected. There are limits to what courts can do. They cannot really legislate. They shouldn't. They do, but they cannot really legislate, and they cannot really question the wisdom of the parliament and the wisdom of the legislatures. Within those limits, one would be much happier to see a more stringent rights reasoning, because that's their job, right? One would be much happier to see a more stringent rights reasoning in the decisions of the courts. And I think to that extent, to the extent that a lot of bail orders, a lot of orders generally go unreasoned, and you see different tests being applied with different levels of intensity across decisions, and judgments giving a certain test for proportionality and then applying certain another test for proportion, things like that, right? That is where I think the Supreme Court has failed, or at least has majorly erred. And that is something that we can expect from the courts. We cannot expect it to challenge the legislature or the executive, but we can expect it to scrutinize legislative and executive actions on a certain standard of rights review. And that I feel is missing, or has been missing, at least in the recent years.
Shweta, what do you have to say?
Um, I have a very cynical point of view, I believe, on this particular matter, and I don't know how to phrase it that does not get me. That's not controversial. So I mean, I'll try to see. As far as Constitution having achieved its goals, I think that, see, when the Constitution, when we were discussing earlier, we were like, we want to eradicate social evils and unite the country and things like those. Unite the country we might have, but eradicating social evils by virtue of merely the Constitution is, I don't think, possible. One, because the legislature has to, do its part. But we have not been able to eradicate the social evils, have we? And apart from that, see, again, the judiciary. Okay, so I won't talk about any recent cases. Let's go back to ADM Jabalpur. That was not upholding of the constitution, was it? So in that scenario, but we do realize that with time, the judiciary also takes certain, bold steps and constitutional morality, as Kashish was also emphasizing on. That is a major point. But I still think that the court, even with all the, even with all the constitutional morality and transformative constitutionalism that is in vogue as of now, I don't think that we're doing our part. I mean, and I don't want to take any particular cases, but see, so there are again, I have to. I mean, I have such examples that I should not be saying, but okay, let me give you this example. So a couple years back, and actually Sarthak sent me this link, and this was being discussed in class, and we were, talking. So apparently there was a petition in the Supreme Court, wherein the petitioner wanted gender-neutral criminal laws, and Sarthak, I believe, at that point was of the opinion that even the Chief Justice at that point, Justice Deepak Misra, he said that the Constitution provides for special provisions for women, and I think he was in support of that. I am not. I don't think that that is justified, and I think that that particular interpretation by the court of just seeing it from a very narrow purview, it's not just, I cannot personally justify it to myself. Just because the constitution provides for special provisions for women, we have a country where, despite having a constitution calling for equality, a man after the age of 18 cannot be raped, and I don't think that that is justified. And I was talking about not controversial examples. Yeah, so yeah, with that I'll just kind of end right there.
Um, Sarthik, I remember you wrote an article on uh, inconsistencies regarding interpretation. It was a very interesting read. So since you wrote on it, I would love for you to elaborate on
No, thanks. In fact, I had raised my hand to bring that specific point here. And I think Ishan, I mean, I'd like to, first of all, briefly comment on both what Kashish and Ishan have said. Really interesting points. First of all, on what Kashish said, that the Constitution, being a dynamic and ever evolving text, cannot fail us. If it has failed us, it is because it is we who have not, who have failed to abide by its principles. And that is what Dr. Ambedkar had also held on numerous occasions. And since we've spoken about Granville Austin, I think it's important to mention that he also felt that constitutions by themselves are inert. And even though it is fashionable these days to say that the constitution does not work, but it does not work because we haven't worked the constitution as it should be. And secondly, on the point of interpretation, Ishan very brilliantly said that the court is essentially abdicating its duty in at least two ways. The first one, I mean, it's not really an abdication of duty in the first sense. It's more of the citizens' expectations from what the role of a constitutional court should be. And the more we rely on courts to strike down legislations, which of course they should do using their powers of judicial review, if any legislation contravenes the constitution, their role is they can only do so much. And when a bad law comes in, our criticism should be more towards the legislatures. Why have they framed a law in the first place, which is ultra vires to the provisions of the to express provisions of the constitution, rather than saying, look, the court is taking so long to strike it down? Of course, that's a criticism of the court as well, but this criticism often takes away the criticism that is due of the parliament. And secondly, I think that's the point that you wanted me to elaborate on, which Ishan talked about. That is, the court is abdicating its duty to indulge in a thorough rights reasoning. And this is something that Dr. Chintan Chandrachud has written about in his paper in the Oxford Handbook of the Indian Constitution, where he says that this era that of the Supreme Court that we're living in, he has called it, quote unquote, panchayati eclecticism. That is, the Supreme Court has started sitting in various benches of 2 judges, 3 judges, and each effectively forming various sub-Supreme Courts within a larger Supreme Court, where each bench gives a judgment that is contrary to what a different bench has held. This effectively gives rise to a doctrinal inconsistency and incoherency across the spectrum, causing great deals of confusion. And when I had written the article, I had taken the example of the Puri Rath Yatra case, because we had seen the Supreme Court allowing the Rath Yatra in Odisha, but refusing to give any cogent reasons, rather than saying, okay, you maintain social distancing, this and that, and this will happen, so you can go ahead with it. But when the same petition was moved in the Gujarat High Court, the court said, no, the situation in Gujarat is different, therefore the procession cannot occur here. And that, in my view, was essentially because the court did not indulge in a thorough rights reasoning. Had it laid down clearly under what specific conditions could the procession take place, what if it had balanced the right to health and the right to religion, which was essentially in dispute at that time, in the manner it should have, probably these questions would not have arose. And so that's what I feel, and that's what I think Ishan is also talking about, that the court's most prominent abdication of duty that all of us can see is its inability or inefficiency or just apathy to indulge in rights reasoning, which is any constitutional court's duty. Thank you. And again, I'm sorry for rambling on. I took a lot of time.
No,
Thanks.
I really agree on what you said, Sarthak. There's been a lot of discussion on the institution that the CGI itself is, and the dual responsibility it has. There's been a lot of advocacy on evolving the traditional master of the roster system, which essentially you're talking about, and how it leads to inconsistencies, and also how it could potentially lead to misuse of power by the Chief Justice, because they essentially decide who's going to sit where. And and I'm sure you know that in Keshananda Bharti Part Two, there was the same thing with the then Chief Justice, right? So they, of course, this is not visible to our own selves. As law students, we're sitting here as even normal citizens. It's not really accessible for us to see. So there's been, again, in extension to this, on the need for more transparency. The SC Collegium is heavily criticized, whether it's our previous Chief Justice or the one before that. There's been a lot of call for more transparency on that part. Kashish, would you like to add anything?
I believe, I think I just want to end on a note that this was a very productive and fruitful use of our time during the pandemic. And I think, yeah, I mean, what Sarthak just said, that if we have more concrete reasons, we have a sounding board to decide whether to see for ourselves, not just us, but even people who are not particularly from the legal field, for them to check whether the Supreme Court is abiding by the rules they're laying down. And definitely transparency on all fields. And transparency specifically, I believe transparency and just proportionality, when it's and proportionality or a response that is not dependent upon who is approaching the court or just any muddiedness. I believe even if at this point we want to believe, we want to put our faith in the Supreme Court, what we have seen previously, I believe that will complete, like, I believe somewhere it is chipping away the faith the people or even lawyers have in the Supreme Court, and that is something to work upon. I believe now is as good a time any, and it doesn't make sense for me to see the Supreme Court or our judges or even the legislature to be shoving this issue under the rug, that everything is okay. Maybe we do not need to be putting up a front, and we need to realize that the people and the lawyers of our country are maybe not entrusting the courts anymore as much as they used to. And I believe it is a real issue, and I believe this is an issue that needs to be looked into, and changes maybe underway. And yeah, thank you for calling me here. I think that's where I want to end it.
Yes, Ishan.
Yeah. So two things to that. One is that if the court takes on itself to be the repository of all fairness and justice, right? It's dispensing justice, and there's a lot of people. There's a lot of talk on how fairness and justice are interconnected, and one cannot exist without the other. We really need to foster an institution that is legitimate, and by legitimate, and legitimacy often comes from transparency. It comes from there being some sort of fairness in the way this institution is run. And um, and I, I think Kashish has already addressed this very well about how a lot of faith that we have in institutions depends on how responsive they are uh, to our own concerns. And what you see with the roster, and what you see with the way things get listed in the Supreme Court, etc., etc., there's certainly um, these could certainly be better. These could certainly be more transparent, and that would, in an era where we find the legitimacy of all institutions in a way getting eroded, and I think post COVID we're entering into a whole new era. I think we need institutions that we can trust, and that we know are certain to function in a way that are certain to function in a way that promotes the welfare of citizens. And I think yeah, that's where I'd like to end.
Shweta, your concluding statement.
Yeah, so I believe that people rely on the Supreme Court more than they do on the legislature, maybe because of 2 points. One being that despite not being elected people in the judiciary, the judges are, I mean, that could be just my own perspective, so no offense, but the judges are still considered to be people who are intellectuals, which cannot be said about the politicians on that regard, at least not all of them, right? And the second one could be that simply the Supreme Court and the judiciary, that is the judiciary, it basically acts as, it's the last resort that a citizen has to go and challenge something that the legislature brings. When the legislature brings a legislation, still it's not the last thing on the table, right? It's not the last line. It's not until we go to the Supreme Court and the Supreme Court says that no, this is correct, that you know that you're left with no remedies. You cannot do anything more about it. That's when you are left out of sorts, because there is no alternative remedy that you can kind of achieve. You could go again for the same appeal of it in the Supreme Court, but after judiciary you have no resort. You could raise your voice, but I mean, doesn't really seem to work, as far as I can see, at least in the present times. And therefore I think that people rely on the judiciary more, which burdens the judiciary more. It would be a utopian concept wherein the legislature takes some accountability of what they're drafting, because I mean, as at least for the last 2 years, I'm noticing that almost every bill that they bring is being challenged on some ground or the other, because it is not being deliberated properly, as in even following the guidelines that are laid in the constitution, because of the opposition walking out and things like those happening. But still, I mean, even after the not so perfect interpretations being brought in by the judiciary, and obviously the recent lack of faith that is stemming out of their decisions that seem to favor or be kind of influenced by the state, I still think that, I mean, I still believe that judiciary does stand as an institution which, despite some of its erroneous decisions, is a place where you can seek justice. Because if you don't have faith in judiciary, then I mean, then we won't be very well off, right? So it's not like it's not a choice. You need to keep faith in judiciary. You can criticize all you want, but I mean, if I don't have any faith in judiciary, then I don't know where this country is going at this point. Because then, if I have a problem with what the legislature is bringing about, and I don't believe that the judiciary will do anything about it, then what's my resort? Should I shift to Pakistan or what? Right? So yeah, that's my concluding remark. Thank you.
Thank you, Shweta. Sarthak.
Yeah, thanks, Sanchit. First of all, just to the original question that you started with on the issue of matters of, the master of the roster, that the role is which is played by the Chief Justice of India. So I feel, be it judicial appointments, be it listing of matters by the registry, or the arguments being made in the courts, it all boils down to, just like Ishan and Kashish have said, to transparency. And when in the name of transparency, the only thing we have going is live tweeting by Bar and Bench and Live Law on Twitter, and recently a high court has started live streaming as well. So we need more transparency, of course, and with transparency, once the courts are opened up to more scrutiny, I believe they should start indulging in a thorough rights reasoning, and all the criticisms that are being raised against the court will be properly addressed. And in conclusion, thank you so much for calling me, Sanchit. Always a pleasure to do this with you. And Kashish, Ishan, and Shweta, it was so nice to see you all, even though I couldn't see Shweta, but a very healthy discussion, and I got to learn a lot. Thank you so much.
Thank you so much. Thank you, Kashish. Thank you, Sarthak. Thank you, Ishan. Thank you, Shweta, for joining in. And I gave you short notice. I think I got in touch with you yesterday or the day before yesterday. Despite that you're able to make it, it means a lot that you're able to join in. And it was truly a productive discussion. And I hope to have many more such discussions with you guys. Thank you so much.
Bye, Sanchit. See you. Bye, Ishan. Bye,
Thank you.
Kashish.
Good luck,
Bye.
everyone.
Bye.
Hi guys.